Chief Justice, Associate Justice, and may it please the Court, I, Uyen Tran, and partner Brayan Cortez will represent the state of Missouri in this case before you today. We will each speak for 10 minutes. Because we believe in the U.S. Constitution and the First Amendment, which states, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of the people to peacefully assemble and to petition the government for a redress of grievances. We believe that this court should upheld the lower court ruling in favor in the respondent. This case evolves around 4 essential facts. 1. Article 1, Section 7 of the Missouri Constitution is current law that the state of Missouri operates under and the same law that this grant was awarded under. The Missouri Supreme Court has ruled on this case and has favor in the states. 3. The U.S. Supreme Court should not be ruling on this case because it has no ability to, which brings me to my next facts. Original doctrines of the U.S. Constitution show that nowhere in Article 3 that the Supreme Court should have the ability to power of judicial review, and therefore this case would fall under Amendment X and be sent back to the state which has already ruled upon it. There are 4 main arguments. I will elaborate on the first 2 and my partner will elaborate on the last 2. 1. Article 1, Section 7 of the Missouri Constitution is the law. 2. Missouri State Supreme Court has already ruled upon this case. 3. The U.S. Supreme Court should not be ruling on this case because it has no ability to. 4. Original doctrine of the U.S. Constitution states that nowhere in Article 3 that the Supreme Court should be granted judicial review, and therefore this case would be sent back to the states. Article 1, Section 7 of the Missouri Constitution clearly states what the state of Missouri can and cannot do regarding money and a church. Since Trinity Lutheran Church is church, they cannot let the money from the state flow into the church.
Counselor, is it your assertion that a church is a church no matter what you call it?
Yes.
Okay, continue.
So this law must be upheld today. Public aid for religious purpose, preference, and discrimination on religious ground. That no money shall ever be taken from public treasury directly or indirectly in aid of any church, sect, or denomination of religion or in any aid of priest, preacher, minister, or teacher. So as such, and that no preference shall be given to, nor any discrimination made against any church, sect, or creed of religion or any form of religious worship.
Is it your assertion that by giving money to the church, you are actually going against what the state constitution says?
Yes, Your Honor.
Continue.
Note that Missouri did not claim to establish a religion or deny Trinity Lutheran Church the ability to practice the religion, but by funding the grant, they are going against their own constitution and making an unconstitutional fact. So can the Supreme Court of the U.S. create an unconstitutional act? If they can, they took out their logic because they are the legislator is supposed to create the law and the executive is supposed to enforce it. But by giving this grant, they are doing all 3.
Counselor, explain. I think I understand what you're talking about, but the judges of the court are supposed to judge the case before it, correct?
Yes, Your Honor.
They're not supposed to create new laws or to
Yes,
do anything else. And if they do that, what ends up happening, they take up too much power, correct?
Yes, Your Honor.
Continue.
Reason to prefer. The United States federal government in form of the United States Supreme Court would instead to have become not only all 3 branches of the government, they would instead create a new law and tearing up the Constitution by giving this grant to the church.
Okay. So in what you're saying is that they're helping the church by not giving money to the church because therefore then the church will not be underneath the state, correct?
Correct, Your Honor.
Continue.
Missouri State Supreme Court has already ruled upon this case. Article 1, Section 6 says that no person shall be compelled to erect, support, or attend any place or system of worship or to maintain or support any priest, minister, preacher, or teacher or any sect, church, creed, or denomination of religion. The Missouri court has ruled that instead of establishing a church, the state by doing this remains neutral. They are equal because they have not given fund to any religious group applying for this grant, same as Trinity. And if you treat everyone the same, doesn't that prove our point of them being neutral?
Now, neutral in your case would be not giving preferential treatment, correct?
Correct.
And if they did give money, then that would be preferential, correct?
Correct, Your
And
Honor.
then that would not be neutral anymore.
Correct,
Okay,
Your Honor.
continue.
Reason to prefer. The state of Missouri has heard this case and ruled in favor of the state. If you apply the Missouri Constitution, Article 1, Section 6 and 7, you can clearly see what a panel of experts on Missouri law did this. They had no choice. The court saw that the state must abide by their own rule and law. So in summary, the petitioner tried to spin a well-constructed story today and see that somehow they are the victim, but let's look at the facts. Did the church apply for the grant? Yes. Is the daycare part of the church? Yes. So can Missouri give the fund to a church according to Article 1, Section 7 of the Constitution? No. Are we a society that follows our law? Yes. So what happened when a state doesn't follow their law? Troubles begin. So therefore, the only option that the state have was to go with the Missouri Constitution and not give grant to the church.
Counselor, that's an interesting position there. Explain to me a little bit more. If they quit following the law, what would they end up doing?
If they don't follow the law, they are creating trouble because they aren't following, and it would create more problems.
So according to the law, they have to follow the law, correct?
Correct, Your Honor.
If they do anything else, they're not following the law, and they could be in trouble.
Correct, Your Honor.
So in this particular case, is it your position in the court today saying that the state had no choice but to do this?
Yes, Your Honor.
Continue.
So the only option for the state of Missouri was to not give grant and follow their laws.
Okay, now one more question before your deal. The question before the court today is: does this establish a religion? And you're saying under the neutrality that by not giving a grant, it does not establish a religion, correct?
Correct, Your Honor.
And if you gave money, that would establish a religion because it would be breaking against the Supreme Court.
Yes. Correct, Your Honor.
Now, in this case, and we're considering we're in the United States Supreme Court, why is it important to know what Missouri ruled on this? Why is the state court important?
Because the Supreme Court says as I stated before, that the Supreme Court is not supposed to see judicial review, and in this case it was from the states.
So it would be back to the state, and the state's
Yes.
already ruled, so therefore this is a done deal.
Yes, Your Honor.
Thank you very much.
Mr. Chief Justice and Associate Justice, and may it please the court, I, Brayan, Cortez, and partner Phuong and Tran, represent the state of Missouri in the case before you today. We will each speak for 10 minutes. Please cross-apply my partner's arguments, and please vote to uphold the lower court's ruling in this case. Argument 3, Article 3 of the U.S. Constitution, powers of the Supreme Court, do not include judicial review. There are only 3 sections in Article 3 of the U.S. Constitution. 2 of these sections deal with this case. Clearly applying Article 3, Section 2 will show that, according to the U.S. Constitution, the U.S. Supreme Court does not have the ability to hear this case today. Article 3, Section 1. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish.
Judges, if you stop right there, who actually empowers the court then? Was it the Congress or is it the Constitution?
It was Congress, wasn't it?
Yeah, and then when Congress can modify things, basically John Marshall's decision, Mulberry versus Madison, would be extra constitutional at least.
Yeah,
not
because the higher law of the land is no longer the Constitution, but the court,
okay.
Or the Supreme Court.
Continue.
So that according to the Supreme Court, okay. The judges both on the Supreme and inferior court shall hold their offices during good behavior, and shall at stated times receive by the services a compensation which shall not be diminished during their continuance in office. Article 3, Section 2. The judicial power shall extend to all cases, in law and equity, arising under this Constitution, the laws of the United States, and treaties made or which shall be made under the authority, to all cases affecting ambassadors, other public ministers, and councils, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizen of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof and foreign state citizens or subjects.
My counsel, I'm a little confused. I thought this is between a citizen or a church and the state. That doesn't seem to fit in any of the original jurisdictions as set forth in Article 3, Section 2, does it?
Can you repeat that, Honor?
Okay, yeah. Of all the things you just listed,
yes, sir.
Nowhere does it say anything about this particular case here today.
Oh, yeah, exactly. So then the Supreme Court has no reason to rule over this as it.
Okay, so it's your assertion that they should never have heard this case in the first place because it's basically not an original jurisdiction, correct?
Yes, sir.
Okay, continue.
Reasons to prefer over the petitioner. A careful look at this section would clearly show that the U.S. Supreme Court would have no ability to hear this case today, according to the U.S. Constitution, because this particular case does not fit into any of the following specified categories. Category A, cases arising under the Constitution, laws, and treaties of the United States, federal question jurisdiction. Category B, cases involving ambassadors, other public ministers, and councils, ambassador jurisdiction. Category C, cases involving navigable waters and morality jurisdiction. Category D, cases in which the United States is a party, United States as a party jurisdiction. Category E, cases between two or more states, states jurisdiction. Category F, cases between citizens of different states, diversity jurisdiction. Category G, cases between citizens of the same state claiming land under the grants of different states, land grants jurisdiction. Category H, cases between a state or citizen of a state and foreign state or citizens of a foreign state, a lineage jurisdiction. Because it does not fit into these categories, the U.S. Supreme Court should not hear this case. Number 4, no judicial review, no case law, no case for the Supreme Court to hear today. Please cross-apply Chief Justice John Marshall's own words in the decision of Marbury v. Madison, 1803. Quote, if an act of the legislature repugnant to the Constitution is void, does it, notwithstanding its invalidity, bind the courts and oblige them to give it effect? Or in other words, though it not be law, does it constitute a rule as operative as if it was a law? This would be to overthrow, in fact, what we established, or what was established in theory, and would seem at first view an absurdity too gross to be insisted on. It shall, however, receive a more attentive consideration. It is emphatically the province and duty of the judicial department to say what the law is. Those who apply the rule to a particular case must, of necessity, expound and interpret the rule. If two laws conflict with each other, the courts must decide on the operation of each. So if a law in opposition to the Constitution, if both the law and the Constitution apply to a particular case, so that the court must either decide the case conformably to the law, disregarding the Constitution, or conformably to the Constitution, disregarding the law. The court must determine which of these conflicting rules governs the case. This is the very essence of judicial duty.
Okay, Counselor, let me ask you a question on John Marshall still. On John Marshall, the original court case had to do with 4 different justices of the peace that were given appointments by outgoing President Adams, correct?
Yes, sir.
And when they were suing Secretary of State James Madison, it goes originally to the Supreme Court. Mm-hmm. And under your point number 3, they should not have even had that in the first place, correct?
No, sir.
Okay, now, so then your assertion is that since they should not have heard the case, they could not make a decision on the case they could not hear, correct?
Exactly.
So then that means that the decision that they made, that Article 13 or Section 13 of the Judiciary Act of 1789 was unconstitutional decision of itself because the court should never have heard the case.
Yes, sir.
Okay, continue.
In essence, Justice Marshall put the Supreme Court above the Constitution. Now the greatest law of the land is no longer the Constitution, but what the Supreme Court said or says is the Constitution. This takes out rule by law and inserts rule by man or woman instead. Considering the absurdity of the idea of judicial review and the fact that ever since the courts have changed the purpose and structure of the U.S. Supreme Court, it is essential in this case to get back to the basics, get back to law, and get back to the Constitution. In that case, the only court that would have jurisdiction is the Supreme Court of Missouri, who heard and ruled on this case already. The U.S. Supreme Court cannot rule on this constitutionality of the state's constitution because it was not expressed in Article 3 of the U.S. Constitution, and therefore would fall under the 10th Amendment to the state of Missouri Supreme Court to decide this case. Since judicial review is outside of the Constitution and was not provided by the Congress, it was clearly illegal and in effect even modifies the Constitution, which goes against you modify the Constitution through the established amendments.
Counselor, now we heard the petitioner's case today, and all they were talking about was case law from judicial review. So are you saying that everything that the petitioner said should be thrown out because none of those cases would have legal standing because judicial review should never have taken place?
Yes, sir. Yes, Your Honor.
Continue.
The petitioner's faulty logic problem. Corporations are not people. This is not the Constitution. We the people, not we the corporations. In fact, the concept that corporations come from case law, 2010 Citizens United versus FEC, and 2014 Burwell versus Hobby Lobby. Case law is a result of judicial review, which has a result of Marbury versus Madison. Sorry. The problem here is that the case should have not been heard by the Supreme Court in the first place. Without hearing the case, they could not have given a ruling, and without a ruling, there would not be any judicial review. This is turned because case law would be not allowed under the Constitution. The petitioner solely relies on the Supreme Court to interpret the Constitution, and this ability was solely obtained by the court through the court and not the Constitution. Therefore, this becomes an independent reason to vote for the respondent. The state should be neutral towards the church. The petitioner is arguing that the fact that somehow they are harmed by not getting a grant they were not supposed to obtain. This harm is manufactured harm. It is based again on case law. You cannot and should not be able to claim being a victim of discrimination that does not and did not exist.
Okay, Counselor, normally when one has harm, you have to be able to prove it, correct?
Yes, sir. Yes,
okay, so can you have a potential harm?
Well, in this case, it actually wouldn't fall in because they were not supposed to answer in the first place because no churches were allowed to obtain a grant. So they knew the law, but they still went for it.
Right. Okay. Now, when I ask that question, if we go by potentials,
yes, sir.
We actually go by actuality. You have to actually have it. It's all hypothetical. Okay. Continue. I understand.
You cannot and should not be able to claim. All churches were not allowed. If we treat all people in a category the same and not show any sort of favoritism toward one particular group or another, is this not being the model of being neutral? This again would be turned because it is not allowed under the Constitution. Therefore, this becomes an independent reason to vote for the respondent. The petitioners are correct that separation of church is not constitutional. However, when you apply logic to their argument, they actually prove our point. Separation of church and state is byproduct of judicial review. The George P. Reynolds case and Everson case, in both cases, it was designed that the founding fathers meant to say separation of church and state. This is faulty logic appeal to authority. In Reynolds, they took passages from James Madison's writing and the Federalist Papers and Thomas Jefferson's private correspondence to come up with this idea. Even though Madison and Jefferson were founding fathers, the only document that can be legally used in this courtroom today is the U.S. Constitution.
Counselor, Jefferson wrote the Declaration of Independence, correct?
Yes, sir.
he did not write the Constitution, correct?
No, sir.
Okay, but the Constitution, we go by what the Constitution says, not by what somebody helped write it on something else, correct?
Yes, Your Honor.
Continue.
The only document, okay, anything else is plain wrong and should be voted down as such. They are correct when it comes to discrimination. However, once again, they have created a victim out of a group trying to break the law. The church clearly knew that the rules going into the grant. They knew that the Missouri Constitution, Article 1, Section 7, would not allow commingling of state funds given to a church. The Constitution clearly said, church. It is equally clear that Trinity Lutheran Church owns and runs a daycare center. It is also equally clear that Trinity Lutheran Church purposely applied for a grant they knew that by law they could not legally get to claim that they were discriminated against. This is a logical fallacy of strawman argument. They applied to obtain state money that was illegal to be given to them. They were allowed to apply but not receive. All grants have requirements. If you award a judgment for the petitioner, you have created slippery slope logical fallacy that will allow all non-awardees to grant the ability to sue because they have been discriminated against. Just because you did not get some. Is that the new level of discrimination in our country? Therefore, we pray that you agree with the lower court rulings and apply the law to this case. Vote to uphold the law and vote for the state of Missouri.
Counselor, one more quick question. The statement here we're trying to look at today was, did this establish a religion by giving money to the, if the state of Missouri gave money to Trinity Lutheran Church, would that establish a religion? Is it your assertion that it would establish a religion?
It would establish a religion because it is commingling with the church by giving it state funds. But it is not allowed, and no Congress should establish a religion in the Constitution, it says.
Thank you very much.
No problem.